application that was filed to strike out the name of ISA and company advocates from the record, that it was not, the physical applications were not presented. The correct position, my lady, is that they were presented, but we were informed by the registry that in view of the fact that the court was sitting today, that the appropriate thing to do would be to come and seek leave of the court before the documents are received at the registry. So it is not true that we did not serve those documents. Secondly, my lady, regarding the documents, there's also an important point, my lady, to point out, which is that the affidavit filed by John Githongo, he had filed a response first, then he filed a further affidavit out of time, and in that further affidavit, he introduced completely new documents. In fact, as you will notice when you retire to write your ruling, he now withdrew the initial logs that he had attached to his affidavit and filed completely new ones after we had responded to his previous affidavit. The only option available to us, having been served with these new documents, was now to respond to them. You'll also notice, my lady, that the documents filed by Arnold Oginga, again, they are completely new documents from the ones that had been filed earlier. The prejudice is, on the basis of the document that had been served upon us, we had already responded and filed submissions because our time for filing submissions was very limited. Now we have a situation where new documents have been filed. We have no opportunity of responding to them in submissions because our submissions have already been filed. The only option was for us to file an additional affidavit explaining or answering these new documents and assertions that had now been made. And that is why the documents that were filed out of time on account of the system issues that my learned friend has alluded to. Thank you, Madam.
Thank you.
With your permission, Your Ladyship, my lords, mine are separate and different issues. The first one relates to the orders you made for scrutiny this afternoon.
Please, can you introduce yourself?
Yes, my name is Katwa Kigen, for the first petitioner, together led by by my senior, Mr. Ngatia. It relates to
respondent, you mean?
Yes, first respondent. I apologize for that. It relates to the issue of scrutiny that is supposed to start this afternoon. We would like to request that the court takes on board consideration of the issues of security, considering what happened at the National Tally Center, my lords and your lordships. And we would also like that the issue of the location where it is to be done be addressed. And we would prefer, considering the security issues also, that camera surveillance be addressed, my lords and my ladies. The second issue, my lords and my ladies, is you granted permission to the Attorney General to introduce 2 affidavits, and we would, the 2 affidavits introduce very substantial facts that go to touch very seriously on our case. And we would like and pray for leave to respond to those affidavits, considering that you've allowed them in. Thank you, my ladies and my lords.
My lady, the Chief Justice and judges of the court, my name is Charles Kanjama for the ICT professionals who've been admitted as amici. I have also 2 requests to make to the court. One is that in respect of the scrutiny that will be taking place, that the amici whose assistance to the court is to give independent observation of the election technology be allowed to participate and also be allowed thereafter to prepare and present their own independent report so that they can effectively assist the court. Second, in relation to the technology affidavits that have been filed late in the last 2 days, the amici in their initial report had responded to the initial technology affidavit so that they could give an independent perspective from ICT professionals who would request that they also be granted leave so that they can supplement that report by also responding to the subsequent technology affidavits which this court is considering whether to admit. That is all.
My Lady Chief Justice, my name is Mituga. For the petitioner, in petition 004, I also have a problem of experience by the rest in filing documents when there was a system downturn. Our rejoinder was supposed to be filed on 28th, but due to system problems, although we filed our set of documents serving as a rejoinder, we presented them to court yesterday. When they were stamped as filed out of time, in considering the rest of the document filed out of time, we asked the court also to consider the fourth respondent's document, supplementary submissions, the supplementary affidavit, and list and bundle of documents dated and filed on 28th of August 2022.
Lordship, why, in view of all these counter arguments, the petitioners, respondents, filing late, claiming, Your Lordship, if the court could just give us 1 hour to regularize so that no party then excludes anything from the record, that would serve the interest of justice. And I submit, Your Lordship, that then no party will feel that they've been locked out. So we don't go back to Raila 2013, where huge documents are locked out, and we all find fairness in this court.
Thank you. You know, our time is not elastic. There was an order for scrutiny from 2 p.m. So we really have to adjourn now.
I just wanted clarity on the role of the Amici. It would appear that they want to go beyond their role.
Senior counsel, we will deal with that. We are
Yes.
capable of dealing with it. We already gave directions that we will rely on the Amici brief that is already on record. Rulings have been issued to that effect. Yes. So with your kind permission, the court will adjourn, and we will reconvene at 4 p.m. because of the many issues that have been raised.